Hello, this is Matt on the Moon Lambo channel. Just a few days ago, there were two companies, independent of Ripple, who filed amicus briefs in the SEC v. Ripple case, alleging a number of things and citing specific facts. And at the thrust of the argument, it was clear that these two companies were strongly in support of Ripple's motion for summary judgment. And for instance, one of them was a company called IREMET. They happen to be a customer of Ripple's utilizing on-demand liquidity. They, in fact, recently expanded their usage of XRP to include treasury functions cross-border. And I made a whole video where I was talking about that and what that meant and the implications. And then there was also TapJets, which is a firm that if I ever knew about them, I just didn't recall. But it's so interesting. It's another one of those things where it's like, it makes me wonder how many companies out there are using XRP in daily business, and we just have no earthly idea about it. And so TapJets was a private jet charter company, and if memory serves, I believe it was 48% of their customers pay through cryptocurrencies, with XRP having the largest share of that 48%. And there's some really good reasons for that, because when you're talking about really, really, truly expensive private jet flights, even just in the United States, they cited that a typical flight could be $60,000, transatlantic flights in the hundreds of thousands of dollars. Well, you have to pay for all of that up front in that particular industry. That's just the way it works. But if you have to conduct a wire transfer to facilitate the movement of funds for actual settlement, well, that only happens during business hours, and a lot of times that only settles once per day. So what do you do when the weekend rolls around? So it's like if it's an evening or a weekend, you can't charter a private jet, frankly. And so TapJets is basically Uber but for jets. It's that concept. And they solved the problem, which they called the Friday night problem, because business basically shuts down on the weekend if it wasn't pre-planned. And you can utilize XRP, which moves in real time, settles with finality in 3 to 5 seconds on the XRP ledger, and bam, problem solved. And this is the only company on the planet that's doing this. And so IREMET and TapJets, they both wrote amicus briefs, requested, and they filed an application to have that be considered in the SEC v. Ripple case. We're waiting to hear back and see what the judge says. But in the meantime, and very predictably, definitely not surprising at all, the asshats at the SEC went ahead and sent a letter to the judge today, and they're arguing that, of course, for X number of reasons, we'll get into the specifics, these firms shouldn't even consider what they're having to say. So it's the SEC seeking to silence voices of actual XRP users. In this case, companies, IREMET and also TapJet. So I'm going to share with you the specifics of what's going on, as well as opinion from several attorneys within the XRP community. But before we're going further, I do want to be clear, I do not have a legal or financial background of any kind. I am not offering legal or financial advice, and you definitely should not buy or sell anything because of anything that I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. Now, shout out and credit to James K. File, an XRP community member and attorney who shared this most recent legal filing from the asshats at the SEC. And Attorney Filan wrote the following: the SEC opposes the IREMET and TapJet's motions to file amicus briefs, claiming the proposed briefs are improper attempts to offer evidence outside the constraints of discovery restrictions, the rules of evidence, and this court's prior order. Now, here's what Attorney Jeremy Hogan had to say. And his first tweet on this was actually a little bit sympathetic. And you know what? I appreciate that, because I want to hear whether it's good or bad. I want to hear, the straight shooting, which is, we always get that from him. But I'm saying, even if it's news that or perspective that would seem to favor the SEC, I want to be aware of that still. And so here's what Attorney Hogan had to say. The SEC objects to the amicus briefs as they contain facts outside of the discovery evidence and which it hasn't been able to investigate. As a litigator, I feel its pain. A tenet of law is the right to cross-examine a witness, right? And these briefs do sneak new facts in. Yeah, and fair enough to point out. But, given that a lot of what the SEC is doing here is trying to get these amicus briefs, effectively chucked on out of here, is based on technicalities, it just makes me just kind of like facepalm a bit, because I was thinking back to, and there are a number of examples, but the one that first entered my mind was I guess it would have been this past April, when the SEC, they were fighting in favor of having their expert witnesses be able to present supplementary information. You may recall Dr. Albert Metz, who is claiming that if not for not for Ripple, rather, that XRP never would have gone above 2 cents. He ended up, this guy, outside of the set time limit by the court, he requested to file supplementary information. That was outside what the rules set by the court, but the judge actually allowed that. And all of us here in the XRP community were just like, oh my God, why? We're all questioning why. But, judge's discretion, and not everything's going to be exactly how all of us want it to be. But here, now they want the rules to be followed perfectly into a T. Isn't it interesting how that works? Somebody named Mike wrote to Attorney Hogan and said, so are you saying a good chance the judge could agree with the SEC, Jeremy? And Attorney Hogan said, honestly, I don't know what she does with this. Most of the case law revolves around new facts presented at the appellate level, which is a little different. I don't know how she'll rule on this. And then he also took the other side here in a separate tweet, and he wrote the following. The counter argument is that there should be some leeway because the judges can give the amici evidence less weight than normal evidence when weighing the facts. And finally, does it really matter when the SEC provides the judge such a nice summary of the amici's position? And then he shared this screen grab. And to be honest with you, I don't feel it necessary to read through the entirety of what was written by the SEC. It's about a page and a half. But he did highlight this, Attorney Hogan, and so I thought I'd at least read this. And it is interesting because the judge is getting the message either way. And the judge can't just unread this and unhear this stuff here. And so even if these amicus briefs end up getting chucked by the judge is now aware of the information that's in here. And basically what the SEC did is provide a summary of those amicus briefs. And so they're trying to get them chucked out, but they're bringing up all the points that were, a lot of the points anyway, that were in the amicus briefs. And so this part of what the SEC wrote reads as follows. Without any evidentiary support, movements propose offering through their briefs factual evidence on their purported use of XRP. For example, iRemit purports to offer living proof that countless similar companies use XRP for cross-border fund transfer on a daily basis, and claims that it does not use XRP to speculate on it, nor does it consider XRP to be an investment whose inherent value is expected to increase over time. TapJets claims that if TapJets loses its ability to accept XRP as a fiat currency substitute, TapJets will lose significant income, including but not limited to investment in technology developed to accept XRP as a form of instant payment for the flights, significant business growth opportunities, as well as goodwill. Because movements do not support their briefs with any evidence, the SEC would be prejudiced by being unable to evaluate the factual veracity of their claims or show that movements' facts are disputed. Putting aside the evidence cannot be properly presented through arguments by lawyers. Movements' proposed attempt to present evidence through their purported amicus briefs is also improper because an amicus who argues facts should rarely be welcomed. This court also declined to permit other third parties as amici to offer evidence or present witnesses because defendants have the opportunity and motive to acquire the evidence movements would offer, and so permitting movements to present it instead would result in an in-run around the court-imposed limitations on the parties, including discovery restrictions and rules of law. So there you go. Now they suddenly care about exactly dot every I, cross every T. Let's go by the letter of the law here, even though for the almost 2 years now they haven't seemed to care about it whenever it benefits them. But setting aside that fact, they're still they're citing what was covered, and this is important information so far as I'm concerned, within these amicus briefs. And what I love so much about those amicus briefs, and I made long videos about each of them individually, it flies in the face of what the SEC has asserted, that XRP has no utility, because that is what they're asserting in the original complaint. Well, technically there's an amended complaint. That's the one I was thinking of, which I guess is in February of 2021 anyway. But that's what they're actually arguing. And part of what they're arguing again is that XRP has no utility, nothing to see here. It's not even useful. It's just a speculative investment vehicle. That's it. Well, real businesses in the real world say, no, that's a bunch of hoo-ha. And then there is this from Attorney John Deaton, who says, this objection is called, we don't want the judge to consider the truth Time Magazine and thousands of others accept XRP and other cryptos as a payment and does not consider it an investment when they accept it. This is the truth. The SEC wants to hide the truth from the judge. Separately, Attorney John Deaton wrote, TapJet's, iRemit, and XRP holders would not have to file amicus briefs in the first place if the SEC's theory wasn't any purchase of XRP anywhere by anyone at any time is a security. Well, ain't that the truth? And by the way, part of what they highlight, and I think I have it in this thread, was that they're not asserting that XRP in and of itself is a security, so it's not clear why, how iRemit and TapJets would be harmed. Except for that's completely disingenuous, because although we know that the SEC keeps saying, hey, we're not saying that XRP itself is a security and all sorts of stuff to that effect, then when you look at their legal arguments, they are arguing that XRP is a security. And that's exactly why iRemit and TapJets felt it necessary to throw their hat in the ring. Attorney Bill, member of the XRP community, wrote the following. Thanks, James. 2 points that I find interesting. Firstly, why didn't Ripple obtain this evidence in its defense? It could have. That's a good point. And so this is a part of what the SEC wrote. You can see highlighted this. As with the earlier attempts at third-party participation in this case, there is no valid reason why defendants whose position the movements expressly support could not have adduced the facts movements now seek to proffer. Nothing prevented defendants from seeking declarations, deposition testimony, or other evidence from movements. And hey, fair enough thing for Attorney Bill to point out. The only thing I'll add, though, is it's pretty clear, like if you read Ripple's motion for summary judgment, what they're really, because there are a number of ways you could tackle this case, obviously. The thrust, the very starting point, frankly, is that Ripple's legal team is arguing there is no contract, and since there's no contract, there certainly can't be an investment contract. And if there's no investment contract, we don't even need to talk about Howie. And so that's the approach they were going. So sure, they could have gone a different way, but it's like, I guess they don't want to, get into the weeds to that level, at least going down that particular path, at least not out the gate, because it doesn't seem necessary for the approach that they think is most prudent anyway. But point well taken for what Bill said. Yes, Ripple could have done all sorts of different things. I'm just trying to sit here thinking just as a non-lawyer here, what might the rationale be? And there's, all we can do is speculate, frankly, but perfectly fair to bring that up. And then Attorney Bill says, secondly, the SEC claims it is not seeking to prevent iRemit or TapJets to use XRP, but to enforce registration of Ripple's distributions. Therefore, by inference, the SEC does not maintain that using XRP to pay for services is a security. Really? ? Not what I get from reading the amended complaint. Exactly, and so that's what I was saying here, and here's the screen grab that he shared, and he highlighted the relevant portion. The outcome the SEC is seeking to enforce would prevent movements, here we go, let me read the whole sentence. Indeed, movements do not and cannot explain how defendants being required to register their XRP distributions, the outcome the SEC is seeking to enforce, would prevent movements from using XRP or otherwise impact movements businesses. So there we go. So they're just saying, the SEC asshat attorney is saying, you can't explain how Ripple having to register their XRP distributions, how that would harm your business. But again, if you look at the argument, I know they keep saying that, hey, we're just going after Ripple. But then if you look at the argument, they are arguing that XRP actually is a security, and as a result, it's the position of Attorney Bill, I've seen him talk about this, as well as Attorney John Deaton, that as a result of that approach, you don't know for sure what's going to happen when Judge Torres, reaches a final ruling, presuming this is going to end at summary judgment rather than a jury trial. There are a number of ways that could break down in a very important, not that it's necessarily even likely, but it could. It certainly could. Now, Attorney John Deaton responded to that and wrote, the SEC says a purchase of XRP is an investment in a common enterprise with other XRP holders and with Ripple. All units of XRP are fungible with each other, and the price of all units of XRP rise or fall equally. A purchase of XRP is a security that equals all units. The SEC can keep saying all they want, that it's just about Ripple sales, but if true, they would go transaction by transaction made by Ripple. Instead, they say all XRP sales, but trust us, we will give exemptions in secondary markets. BS. Yeah, exactly. I'm not going to sit there and trust them on a bunch of that nonsense. I'll tell you that right now. But because look, here's the thing. Again, like this is why Ripple is taking the approach that they are. There is no contract, which means there can be no investment contract, right? And if the SEC wants to assert otherwise, they would need to, ideally anyway, present examples of specific transactions where violations have made. But instead, the SEC, all they're doing is making really broad, truly blanket statements. But I've gathered from the attorneys that have been covering this for almost 2 years at this point within the XRP community, that's not what would be expected in such a case. You need to break down the specifics. Where were the actual violations? The SEC never makes that argument. Why might that be? Well, might it be because everything having to do with XRP equals security because reasons? That's what it looks like to me. I'm not a financial advisor. You should not buy or sell anything because of anything I say or write. That would be a very, very, very bad idea. Until next time, to the moon, Lambo.